In today's class, I will be talking about community properties. Whether you are navigating marriages, contemplating estate planning, or you are simply curious about knowing the legalities of inheritance, this course is for you. I am Professor Rousseau, and you are following class in session on Apostrophe Podcast. Class, the simplest, the most basic definition I can give you of community property is that what assets do married people propose on together. This simple definition compels us to understand, to consider two important things in community properties: marriage and assets. Practically, community properties refer to the legal framework governing the sum of properties that couples acquire during marriage. Before I go any further, I want you to know that not all the states follow community properties. And the states that do follow those laws, they follow them differently. Practically, what's acceptable in one state may not be in another state. Now that you know the real definition of community property, let's try to understand what kind of assets are deemed community property. As a general rule, all assets acquired throughout the marriage are deemed community property. This includes income, vehicles, real estate, and even debts are also community property. There is a little nuance I want to share with you. I will take two names in the chat room. We're gonna use Jerome and Gina. They are a couple, they have been married for 10 years now. Since the day they got married, Jerome is a stay-home dad, and Gina, we can call her the breadwinner. Where I'm getting at right now, even though it's only Gina who purchase everything in the marriage, Jerome is entitled as much. Let's say Gina, she was able to save enough money to buy 2 houses or to buy vehicles or to save 100K in the first year. Who do you think will get all the money? Better yet, do you think the assets that Gina acquired throughout the marriage don't fall into the community? The answer is everything that are acquired, whether it's one person who purchased them or whether it's both, they both enter the community. And you will see, given your state, there is a legal framework to determine what kind of assets enter the community and who will receive them or how they will be distributed in case of marriage or death. Let me restate, as a general rule, all assets acquired throughout the marriage are deemed community property. However, there is always exception to any rule. That's why right now I'm gonna tell you that not all the properties are part of property community. Property acquired before marriage are not. For example, Gina had a house before she married Jerome. That house is not part of the community property. Also, during the marriage, if Jerome inherit houses, money from his family, those assets do not enter the community. However, there is some legal ramification that I will listen to you later. Now, let's talk about assets that are acquired throughout the marriage but are not part of the community. Jerome went to the casino in Oklahoma and he gambled and he earned $10 or $100,000. Earnings that you earn, that you have from gambling, or Jerome went to 7-Eleven, purchased a ticket, and he just get the mega million, like millions of dollars. Those assets, although they are required throughout the marriage, are not deemed community property. Once again, there are some legal ramifications that I will explain to you later. Now, let's talk about the distribution of those assets, whether one of them dies or if they decide to have a divorce. Two concepts I want you to remember. It is right of survivorship and intestate succession. This concept, the second one, succession, is whenever there are children involved and one of them died or they decide to have a divorce. Before we do that, let's take like one or two scenarios to make you understand better, and we're gonna go back to properties, to assets that are not part of the community property. Let's use first Jerome. He went to Oklahoma to play casino and he earned $100,000. That money, those earnings, are not part of the community property. However, if Jerome decide to buy a house with that money or as down payment, that house automatically enter the community property because it was, even though it was used with money that were not part of the community. Not all the state follow it the same way. This is the basics right now. Anything that you earn before, that you acquire before marriage, or you acquire throughout but not part of the community, if you use that money to buy something in the community, an asset, that asset will be part of the community. Now, let's use Gina. Gina, I told you before, she entered the marriage with a house. Two things can happen. Gina can decide to sell the house. If she had to sell it, even though that house is not part of the community, the realtor is obligated to have both parties sign the bill of sale or whatever they use when they sell houses. Because the law, certain laws, certain states, want to make sure that one of the parties is not left without nothing. Jerome will not give authorization. He will just show that he is aware of a sale that will incur a sale of the house, even though he's not going to inherit anything of that house. However, after Gina sells the house, That money, once again, not part of the community on the state that we live in, but with that money, Miss Gina decided to buy a real estate, to buy a house or anything, or Airbnb. That house now enters the community, even though it was purchased with money that was a part of the community, because they assume that a asset is acquired or was acquired throughout the marriage. Let's tell you something better. Is a nice scenario that you will enjoy. At the beginning, or maybe like in the middle, I said that Jerome, who is not working, his family died and they left for him a house. That house is not part of community property. That house is for Jerome, nobody else. Let's say that Jerome decided to sell the house. Guess what's going to happen? The same thing that happened to Gina. First, Jerome has to get Gina to sign. And if after he sells the house, whatever he purchased with that money will enter community property. Once again, it's different from state to state. This is domestic, and if you know how your state follows community property laws, check out the website. Now, we spoke earlier about something called right of survivorship. In some states, they will tell you every asset that is part of the property, community property, the wife has 50% interest and the husband has 50% interest. Some states will tell you the wife has 100, the husband has 100. Either way, this is the way it works. Let's say that either of spouse that, let's say Gina dies. Gina dies. They all, certain states will tell you they are 100%. Either way, when Gina dies, and I'm talking about the kids here, automatically, without going to any probate, Jerome will have 100% of the estate. He will inherit Gina's 50%. That's the basic for some states. Some people tell you it doesn't matter because they both own 100% of the asset of the house. So when either spouse who dies, the other one gets automatically. What if there are children? Whether or not there are children, because one of the spouse is still alive and he owns 100%, the children, don't get anything yet. The children don't get anything yet because Gina is dead, but Jerome is still alive, whether he has 50% or 100%. So the interstate succession laws do not come to play yet. Class, there are few states in America that do what they call 80-20 split. You know what? Let me give you an example. We still consider Gina and Jerome. Gina has 50% interest for 100, you understand, and Jerome has 50%. In those states, they accept 50-50. Now, Gina dies. I'm sorry, Gina. Gina dies. The way they will distribute the legal framework they will use will be that they will say that Miss Gina will transfer 30% automatically of her interest to her husband, which now Jerome will have 80%. So what about the other 20%? This rule applies when there is a child or when there are children involved. Jerome will have now 80%, and the kids will have the other 20%. Once again, that's when you need to remember the intestate succession. Some states do that. I don't understand why, but once again, is the law, or wherever you live, make sure to know which community property laws your state follows. All right, folks, let's do a quick recap of what we've learned so far. I define community property as what assets do married couples own together. As a general rule, all assets acquired throughout the marriage enter or are deemed community property with some few exceptions. We also talk about how those assets are distributed in case of death or divorce. States use different formula, different legal framework to know who's getting what. Some states use the 50% rule, where the wife has 100 interest and the husband has also 50%. Some states use 100, which each spouse having 100 interest on the assets. Some use 80-20 split. In the first two, 50-50, 100. Either way, if one of the spouse is still alive, the children do not inherit anything. The other one, if you state 80-20, the spouse who is dead is automatically transfers 30% of her interest to the surviving spouse, and the 20% will stay, the kids will inherit them. That's why we mention two concepts that will kick in when we talk about the right of survivorship or in the intestate succession. The kids will earn something, will inherit in terms of divorce or death in those states that do the 80-20 split. Thank you for watching. This concludes my class today. And remember always to consult a professional, an expert, to tell you exactly what your state is doing and what you are entitled to as a spouse or as children. But remember also to plan your life, to plan your estate, to protect your wishes with a will or a testament. Next week, I will be teaching you how to do or why you should have a last will and testament while you are alive, so the court don't decide who gets your assets. Thank you. See you next week.